Good day, everyone. So, today we will be discussing the drafting of contracts with a particular focus on the different types of agreements. So, we have done sale of a business, a lease agreement, as well as a sale of shares previously. So, now we'll be understanding the contracts, boilerplate clauses, yeah, as well as now practical examples that you would obviously come across when dealing with a contract. So we know already that a contract is basically a legally binding agreement that obligates that creates an obligation between parties. To be valid, a contract must meet the following requirements as per law of contract. There must be consensus. The parties must both agree to the terms of the contract. There must be capacity, legal capacity to contract. So you must be able to contract. Let's say it's a minor. You cannot say you entered into an agreement with someone who is under the age of 7. They do not have the capacity to contract. It must comply with formalities. So, for instance, some agreements cannot be oral, they have to be reduced to writing. It must be lawful, so the contract must not be for the commission of a crime or just something that is illegal. And then there must be certainty. Certainty in a sense that both you and I, as contracting parties, we must know what we are contracting to and understand the terms thereof. And then possibility. Possibility refers to the ability or performance of the contract being possible. So, for example, if let's say Nomsa agrees to sell her car to Newo for 100,000 rand, but they never agree on the payment terms, right? So it's not clear whether am I paying it cash? Are we gonna have an installment sale? So essentially, this contract lacks certainty and could be invalid. Let's say now, Newo assumed that she was gonna make payment in two parts, and only to find out that Nomsa expected that Newo has to make payment immediately, like with full. So you understand that then there's a difference in how these now parties are understanding each other. So those are then your requirements in order for a contract to be valid. It's consensus, certainty, compliance with formalities, lawfulness, certainty, as well as possibility. And then we go to section 2. This is now as per the syllabus. We've got the standard contract clauses. These are also known as boilerplate clauses. So when they say boilerplate clause, please do not get confused. These are like really your general clauses that you find in almost every agreement, like the parties clause. At this stage, we know every contract has to identify the parties involved. Who is contracting with who? The definition clause, we need to know, okay, when we refer to property, which property are we actually referring to? And then jurisdiction clause, we specify the governing law as well as yeah, basically the law that is governing this contract. Like let's say in South Africa, I would obviously say the laws of the Republic because it's we are concluding the contract in South Africa, and then confidentiality clause protects sensitive information. So assume they give you a scenario that Newo is contracting with Masego for a sale of a business, but she does not want to disclose it yet. Which clause can she use now to protect this information? Then it would be a confidentiality clause, and you state whatever it is that you do not want the other party to disclose. And what would happen if they would then now disclose that information? What would be the remedy that you would have against them? And then the non-variation clause. So the non-variation clause, there is another word, I forgot it, but there's another word that, oh, Schifrin principle. So when we say in Schifrin principle, we are basically referring also to non-variation clause. So the non-variation clause basically say you may not amend the contract, but if you do amend the contract, you can only amend it with consent of the both parties, and such amendment must be reduced to writing. So that is your non-variation clause, as also known as the Schifrin principle. And then the variation clause, sorry, I forgot that. The variation clause then now would basically deal with the methods in which the parties can vary the contract. So it would just state the terms to which the steps that the parties ought to follow before amendments can be made. So you might be wondering why a non-variation and a variation clause. So with a non-variation, we are assuming that the contract may not be varied. Well, if in the case that we need to vary it, fine. Both parties must consent and such amendments must be made in writing. So that is the premise of a non-variation clause, also known as the Schifrin principle. On the other hand, a variation principle, we are premised on the fact that we can amend the contract. From the time we draft the contract, we are saying we can come back later and amend the contract, and this is how we can amend our contract. But with the non-variation clause, from the get-go, we are assuming that no amendments can be made. If amendments are compelling that they should be made, then we should make them with the consent of both parties, and such amendments must be reduced to writing. And then we've got the force majeure clause. So the force majeure clause basically addresses unforeseen events that would prevent performance. So assume that, like for instance, COVID, like you would then maybe contract with the Department of Education to offer a service, and then the next thing COVID hit, you do not have now funds. Just the world is in a bit of a chaotic state, and it's really something that is out of your control. That's a force majeure. That's basically a force majeure clause. You would then be addressing that, okay, in the event of unforeseen acts of nature, the contract will be, let's say, suspended for this amount of time. And then if not, if really within that period, still, let's say 3 months after, we are still unable to act, maybe now the contract would then terminate, and the parties will be placed in the state that they were, if it is possible, obviously. So your your force majeure clause would highlight issues like, okay, what do we then consider as a force unforeseen event? Cool. And then how much do we have then during that force majeure period? It's 3 months. So let's say it takes 3 months and it's still in that we're still having an unforeseen event, the contract will continue. And then as soon as that 3 months is over, the contract will continue as per normal, right? And then let's say it continues for more than 6 months. So you then also have to account to say that if it goes on more than 3 months, we might as well cancel the contract. And if possible, um, let everyone be in the same place that they were before the conclusion of the contract. So we are basically just retracting the whole contract. So that's what you would basically highlight in your force majeure clause. And then your dispute resolution clause. So dispute resolution clause is where now you determine that, okay, if we've got a dispute, this is the first avenue that we are gonna consider. So let's say we're gonna say we are gonna negotiate. If negotiation fails, we are gonna mediate. We are gonna appoint a mediator. Maybe Neo and I will be responsible for the mediation fees. We will appoint the mediator from maybe this council and. And then if mediation fails, we shall continue to arbitration. Both parties shall remain liable for the arbitration fee and things like that. So in this would be your dispute resolution clause. So you start with negotiation, you come with mediation as well arbitration. You are basically saying if we can't resolve here, we can resolve here. If you can't resolve here, we can resolve here. And maybe you can also add in to say that if all these three remedies have been exhausted and parties have not come up with an amicable solution, what we can do now is we can approach the court. So I suppose they give you a scenario to say that NEWA and NOMSA in the agreement had a dispute resolution clause. And then now NOMSA runs to the Johannesburg High Court and did not exhaust the remedies. Can this be allowed in terms of a contract? No. We first have to exhaust the remedies as stated in our contract before we rush to the court. And then indemnification clause. So it basically defines liability coverage in a sense that, let's say, mostly it happens if you see at a mall, they would indemnify themselves and say, if you park here, we are not going to be responsible for your loss or damage that basically happens to your car or anything, you park here at your own risk. They are indemnifying themselves in terms of should a loss occur, should damage to your property occur or anything, they are not involved. So they are basically um limiting and limiting their liability and making sure that they cannot be held liable in case of such happen. So that's what your indemnification basically deals with, to say that okay, but we are contracting. If this happens, please just bear in mind that I will not be held liable. So let's say Neo and Nomsa enter into a contract, and Neo is a retailer of computers, but now she wants to appoint Nomsa as someone who will do the deliveries. Then between themselves, they would add a clause to say that in the instance that during the delivery, Nomsa, um, by by virtue of just maybe a mistake or whatever, the what's this? The computers get damaged or some sort of failure is identified on it, she will not be held liable. Or if she says she'll be held liable, she can say she will only be held liable to the extent of 1,000 rand. So she's basically saying, if I get into an accident with your computers, even if the value of those computers can be 50,000, I will not be held liable for 50,000. I will only pay you or reimburse you. What's this? 1,000 rand. So she is limiting her liability and also indemnifying herself of any further claim. And then we've got severability clause. So this clause ensures that the rest of the contract remains valid if one part is void. So assume that in a part of a contract, remember we also did this when we were dealing with constitutional law. So in a part of a contract, let's say there's literally one clause that is now making the whole contract invalid. So what we can do, we can say, okay, fine. Each clause is severable from another, meaning that if we find one clause inconsistent with what we are trying to achieve based on this contract, we can remove that specific clause and then the whole contract would still remain in force. That's basically what your severability clause deals with. And then we've got breach and termination. Breach and termination establishes the consequences for non-performance or failure to pay. Basically, you defaulting with any term in the contract, we would come up with a breach and termination clause. So your breach and termination clause, one thing for sure, it will always state what it considers as breach. And when can that breach be remedied? Let's say within 7 days. If you fail within 7 days to remedy the breach, then what happens? Maybe the other party will terminate the contract and will further exercise the legal rights under this contract. So you've got three things that you should always mention in your breach clause. So it would be, what is the breach? What remedies available under the breach? You don't always have to cancel the contract. So meaning I can give you 7 days to remedy the breach. If you fail to do so, what's going to happen? I am going to exercise my rights under this contract. And then you come up with your example. Like I'm going to, let's say, cancel the contract and then you have to vacate the premise. Let's say it's a lease agreement, then you vacate the premises within this period. Or let's say it's payment, you have to pay me, failing which I will proceed maybe to appoint a legal person to assist me to collect the monies, and of which you also be liable for now the cost that I have to incur in order for you to bring into terms. And then cession and assignment clauses. So this regulates the transfer of rights and obligation. What do we mean by this? So decision and assignment, I've got a contract, Noms and I got a contract, I've got a lease agreement. And then at maybe, let's say 6 months into the 12 months agreement, I feel that, okay, I don't want to live here, or I don't want to operate my business from these premises. I want to cede my rights to Masejo. But I can't just do that without the permission of the lesser. So it means that now, based on the contract terms, let's say it says that I would have to first ask for permission. We covered this in our lease agreement. Ask for permission. Um, which such permission will not be withheld without reasonable without reasonable, basically fair reasons. So it basically talks about you cannot cede your rights unless you have first asked me as the person whom you are in contract with. And so in your cession and assignment, you'd first state that this is what you should not do under this agreement. And then you can only do it by permission from the other contracting parties. So that is your cession and assignment. You're basically what you're obligated to do under the contract. You are passing it over to someone. But by a contract, you're not supposed to do so. And then we're gonna state the reasons why you shouldn't do so. And you can only do so if you have now found concern, let's say received consent from you, basically. And then waiver or limitation of liability clause. This limits the amount of damages recoverable, right? Just like your car insurance. Your car insurance, you'll probably, let's say the value of your car, it's 300,000, and then maybe they limit the coverage of the damages to 200,000. So they are limiting it. So suppose they tell you that draft a limitation of liability clause. You would just be limiting the liability to a certain amount or to a certain act. And then waiver clause. So basically your waiver clause is where now you are preventing a party from unintentionally giving up their rights, like your legal professional privilege as you spoke the other day. Only the person who owns the privilege can waiver it. So you would also state in your contract, the concerned party in the contract shall have the right to waiver their rights when they deem so, and no one shall assume waiver of rights on behalf of the other. Basically saying, me as the right holder, I'm the only one that can expressly state that I am waiving my right. You cannot decide on my behalf that I am waiving my rights under the contract or have another party assume it on my behalf. And then the entire agreement clause. So this one states that the contract is full agreement between the parties. So this is just basically saying all parts of this contract are the full agreement of these parties. We are not going to read the agreement as page 125 is the agreement between Neo and Nomsa. Unfortunately, the whole contract is applicable to the parties. And then we've got a deed of sale. Ne? So a deed of sale, we covered it a bit in your sale of business as well as the sale of shares. So a deed of sale automatically, it's when something is being sold. So if they ask you, draft a deed of sale and it speaks of shares, just know that they are referring to a sale of shares. Something is being sold, and if the scenario speaks about shares, it means that deed of sale that you'd have to draft is your sale of shares. So it's both for movable and immovable property. So property can be sold using a deed of sale or movable property. So the typical clauses include parties. We know this at this stage with our business agreement as well as sale of shares. We describe the property. We'll always state the purchase price and the payment terms. How do we pay it? When will transfer of ownership take place? The risks and the benefits. When do they vest on the buyer as well as the seller? The conditions such as finance, securing finance. So there are two conditions that the LPC likes in their exam. We've got the suspensive condition. A suspensive condition is something like this. Nomsa agrees to sell her house to Masego, for instance. But then the contract states that the sale will only be effective if Masego secures a home loan within 30 days. If the condition is not fulfilled, the contract will not come into effect. That would be your suspensive condition. Yes, we're entering into an agreement, right? But if NOPSA if Masego does not get a home loan within 30 days after concluding this agreement, then the contract will not come into effect. And then the other one that we've got is a resolutive condition. NOMSA sells a farm to Neo with a clause stating that if Neo does not use the land for agricultural purposes, within 1 year, the contract will be terminated and ownership will revert to NOMSA. So we are basically saying here, you know what, I'm selling you this, but please do this. These are the terms. If you fail to do this, the contract will not be in effect. So the contract is based on you performing 1, 2, 3. That would be then your resolutive condition. So that here I just wrote an example of your deed of sale, what you would consider as a deed of sale. So here it was just be Nomsa selling a house to Masejo. And then we've got an acknowledgement of debt. So we've got the first clause is admission of the debt. So in the admission of the debt, you are basically saying, I, the undersigned Nomsa, um, I am hereby indebted to Newo in the, yeah, basically something like that. You are admitting the debt. And then now the next clause is the interest. In the interest we are dealing with, okay, what interest is applicable in terms of our agreement. And then early repayment, what happens if now Nomsa is going to pay back Masejo earlier than she had anticipated? What happens to the agreement? Obviously now, once the full payment is settled, the contract will, I mean, the acknowledgement of debt shall be satisfied in full and all parties would have acted. So you're basically addressing the issue of what happens if I pay you early? It means that you don't owe me anymore. And then additional charges. Additional charges we are referring to what happens now in a situation whereby you have to act like appoint attorneys in order for you to recover the money. So that would be you now saying, okay, fine. If I have to incur extra expenses in having to enforce this acknowledgement of debt, this shall form part of your acknowledgement of debt, and I mean your principal debt, and then the default, basically same as your breach. What do you consider as a default? When can you remedy the default? Failing which, what can I do? And then proof of indebtedness. Proof of indebtedness basically talks about what do we consider as the proof of debt. Exactly this, just this acknowledgement of debt, we can state that, okay, this acknowledgement of debt shall serve as proof of indebtedness to NOMSA, because we've got proof. You are saying I, the undersigned, no, actually, Masejo, you are saying I, no, it's actually NOMSA. But yeah, you get the gist of it. So the proof of indebtedness, because you already stated in your admission of debt, to say that I, the undersigned NOMSA, um, I'm indebted to and whatnot. That's proof that we have proof that you are indebted. But also, if you've got another contract or another liquid document, that shall also serve proof serve as proof of indebtedness in terms of this contract. And then we've got legal costs. All costs that we had incurred in this process shall also form part of the debt. Now, this is also extends to VAT. If we have to incur VAT, it shall also form part of the principal debt. And then surety agreement. So surety agreement is basically me saying, um, I'm borrowing money, but can Mary stand as surety to the contract? Meaning, if I can't pay, maybe Masejo can now go and try to recoup the money from Mary. So that's basically a surety. So we are going to identify the surety as well as the data. So the data is me, and the surety would obviously be the person who's now can be held liable. We have to identify the principal debt amount, limitation of liability. Mary can say, okay, you guys owe each other 1,000 rand, but now I can only be able to pay 500. And before you even come to me, please make sure that you have exhausted all avenues in attempt to recoup the money from Sheila. So she is limiting her liability in that sense. And then waiver of legal expectations, she can say, okay, fine, please, um, your legal expectations can only be waived expressly by myself or the parties in this agreement. So another example would be Neo borrows 50,000 rand from Masejo, and Nomsa agrees to be surety. This agreement must specify that Nomsa is responsible for the debt if Neo fails, but it's not automatic. You can state that there's certain avenues that the person has, like Neo has to exercise first before she comes for NOMSA. And then we've got a power of attorney. So power of attorney, there are two types of power of attorneys. We've got the one with the general mandate. So it's broad and it gives powers for one to act on behalf of another. So suppose I'm going to the UK for like 5 months. I can give power of attorney to Mary and say, Mary, please handle all my affairs in South Africa while I'm away. Anything that has to do with me, please attend to it. And then a special mandate would then be limited to a specific task. Let's say I'm selling a car. I would expressly say I'm selling the car please deal with the sale on my behalf. And once the car is sold, the mandate would then basically lapse. And then another example, yeah, it's the overseer example I just gave. That would be it. And then decision, delegation, and assignment, I have dealt with it, but and they stated it twice, so it's okay because it mainly forms part of the lease agreement or your contract. So in your decision, you are basically transferring rights from one party to another. Delegation is basically you transferring your duty that you have to act to another with consent, and then assignment, you transfer both rights and obligation to another person. So Neo sells his debt to a collection agency, ceding his right if Nomsa hires Masejo for work, but then transfer the duty to Neo. That is a delegation. So sale of a business in shares, we did it. Lease agreement, we did it. And then a letter of demand and cancellation of an agreement. So a letter of demand, you're basically having identified that, let's say someone owes you, né? And you are now trying to get your money back. The first thing you would do, obviously, draft your, what's this? You draft your letter of demand. So letter of demand must contain the issue, the required action, as well as the deadline for compliance. So the issue, let's say, Masejo owes Neo owes Masejo 5,000 rand, ne? And then Masejo sends a letter of demand demanding payment within 14 days. The letter of demand would obviously come at a stage whereby now Neo feels like really, actually no, Masejo feels like really the payment date has lapsed. You have not made means to pay me. I've tried to reach a solution with you. You have failed. So I'm sending you a letter of demand and placing you in terms to say that on or about to enter into such an agreement. The agreement was you would pay. I would borrow you 5,000 rand, and you would pay me within 30 days from receipt of the loan. You have failed to do so in terms of the agreement and in terms of what we agreed on based on blah blah blah. And I need you to pay me and within 14 days, failing which I will further exercise my remedies. Let's say now issue summons against you and things like that. That is your letter of demand. You highlight the issue that Masejo, I mean Neo, you owe me. I need you to pay me, and this is the deadline for compliance, failing which I will exercise further rights under this agreement. I will send a example of a letter of demand in the group, just so that you guys have an idea in case you are not a candidate attorney. And then we've got an employment contract. So an employment contract, we know, number one, an employment contract has got parties. So parties, obviously, as per normal, just give me 5 minutes. I just want to switch off my pod. Okay, I'm back, guys. So your parties, as per normal, we know who's the employer, who's the employee. We need to define that. Your definition, when we refer to the place of work, for instance, you can say the address of employment, whatever, you state the address. When we say bonus we are referring to, it's just maybe three or four terms that you need to be clear about in terms of your agreement. They cannot be strict about this. It really can be just any term that you feel that let's define it for clarity. And then the appointment would obviously state that from when are you being appointed, the duration would deal with the duration of the contract. Is this a fixed term contract? Is this a permanent contract? And things like that. Remuneration, when do you get paid? When are you receiving your monies and things like that, as well as your bonus that you maybe, let's say you're not entitled to bonus, or bonus will depend on performance and things like that. And then expenses, what expenses can the company incur on your behalf, like let's say your travel expenses, maybe when you go for presentation for work, just depending on the nature of the business. Company vehicle, when are you entitled to your company vehicle, things like that. Executive functions, This one has a more, they just threw it in, but there is a specific question. I also share it on the group, but these are for like executive roles. And then, yeah, 1, 2, 3 are for executive roles. And then confidential information. How do we treat confidential information of the company? Company profits shall remain that of the company. Even if you as an employee generated a lump sum profit, you're not entitled to it. The only thing you're entitled to is your remuneration. Unfortunately, the fact that when you dealt with a rough method or successful client was paid, it does not mean that now when you must claim it or anything after the company has received their contingency amount, their contingency payout. You cannot say, I as now I was working on it, I'm entitled. No, it's basically addressing that. And then documents, all documents of the company belong to the company and shall remain the property of the company. And then policies, you shall state that the policy of the company shall be followed. These now include your HR policies and various policies that are basically in the work structure, like your IT policy and things like that. You further state that these policies need to be observed, and failing which it shall be considered breach. And now we obviously know what breach is at this stage. And then disciplinary procedure. Here you are basically saying, in the instance of a disciplinary procedure, we shall issue maybe a warning. Maybe at the third warning, you will be taken to a hearing and things like that. You are basically detailing. There is no strict way in terms of how a disciplinary should be held, but before you can say disciplinary procedure shall resort to dismissal, you can't just dismiss a person. You can state, however, in your clause that maybe, let's say, dismissal may be used in an instance where there's gross negligence, gross dishonesty, or you have really grossly prejudiced the company. Then yes, they might be entitled to dismiss you. You can also mention things like when can you refer the matter to your tribunal and things like that. And also that should you be in a disciplinary hearing, you're entitled to call an employee to represent you, stuff like that. There is no uniform rule to say that this is the disciplinary procedures that you must strictly follow. Any company can state that, okay, fine, this is what we consider justifiable for us to instantly dismiss you. This is what we consider you having to have a warning. After 3 warnings, this is what happens. You're going to go to your hearing, present your case, and then we take it from there. So it's things like that that you would mention under your disciplinary procedure. Statutory obligations. What are statutory obligations under the contract? To observe the policy as well as the rules of the republic that are governing the contract. Leave. When are you entitled to leave? What's the leave days that you're entitled to? Things like that. Pension fund, what's the amount of pension fund? What pension fund are you entitled to? Is there even pension fund and things like that? And then termination, when shall the employment contract terminate? What notice should you serve? Things like that. It is broad. Really, this contract, I don't think they would ever ask you to draft it completely in full, but they can give you maybe bits and pieces, which would then be under the questions that you would find also with your LRA. Then they would maybe say draft a leave clause for an employee, or draft a termination clause, or a notice clause, or a disciplinary procedure clause, since it goes hand in hand with your LRA. And then we've got agreements, credit agreements, as well as the National Credit Act. So credit agreement includes things like loan agreements, repayment, credit agreement basically must include loan amount, repayment terms, interest rates and fees, consumer rights, and protection clauses. I do not necessarily think they would ask you to draft this, but they might ask you to draft a section 129 of the National Credit Act, letter of demand. I will also share that with you guys on the group. So that's it for contract. If you do need more help or anything, please just always DM me. But other than that, one thing about contract is you must be able to understand what you need to address in the clause. It's not really that strict. Once you have an understanding of the clause, you do not need to memorize the clause examples stated in the textbook. You just need to understand what needs to be in the clause. What 3 elements do I need to highlight? And once you understand that, then you obviously going to find it much easier for you to draft a clause anyhow, because there's no standard wording that says this is how a clause must look, but rather this is what the clause must address. Like when we say a suspensive condition, what is the condition? What must be done to fulfill the condition? If the condition is not fulfilled, what will happen? You understand? That's how you address what needs to be in the clause. If you guys have any questions, then you are more than welcome to DM me. Otherwise, I will share the video again now, the one dealing with the different questions in the drafting of contracts from 2015 to 2024. Some are repetitive, so I will just need to filter that out to see which contract was repeated over the years and just sifted to just the contracts that did not repeat but were there. Like if a contract repeated twice, I'd obviously not redo the question twice, but just once. Other than that, that's it from me, guys, and bye.